Let me go ahead and we'll just go ahead and do a roll call. All right. Steve Hanna? Not with us. Donald Wynn? Donald Wynn? Okay. Patrick Wren?
Here.
And Dr. Christy Halbert?
Here.
All right. Thank you. We do have quorum. We'll go. Let me go and read the statement of necessity since we have since Donald's calling in, and we'll jump in from there. The Tennessee Athletic Commission called a regular meeting of the commission to discuss the agenda as noticed on the website prior to the regularly scheduled meeting. However, commission members were unable to meet in quorum in person on the regularly scheduled meeting date of September 10th, 2018, due to the unexpected out-of-state travel of one of its members. Pursuant to TCA A44-108, unnecessary matters considered by this governing body at this meeting requiring timely action, the physical presence by a quorum of the members is not practical within the period of time requiring action, and participation by a quorum of the members by electronic or other means of communication is necessary. In this instance, the commission members needed to conduct a regularly scheduled meeting in order to meet the commission's statutory required minimum number of meetings. Quorum was not practical and quorum by electronic means was necessary. Decision of the board will be confirmed by roll call vote. If we may, we'll go ahead and take a roll call vote to accept that statement. Anytime we do a teleconference, we have to basically do a roll call vote for everything that we have to move on. So if that statement is acceptable, do we have a motion in that regard? All right, Dr. Christy Halbert, motions that we accept the statement of necessity. Do we have a second?
I'll second.
Patrick Wren has seconded. Unless there's any further discussion, for voice vote, Donald Wynn, a yes or no, or aye or nay will get it. All right. Patrick Wren?
Yes.
And Dr. Christy Halbert?
Yes.
All right, thank you. That was accepted. We'll move on to the notice of the meeting. Notice of September 10th, 2018 meeting of the Athletic Commission was posted to the website on August 24th, 2018. If you had a chance to look at the agenda, we typically try to stay in succession as printed, but to meet the scheduling needs of Mr. Wynn, we'd like to move all the actionable items to the front. So if the board will permit us, we'd like to have some freedom in those items. If that's okay with the board, if we can have a motion in that regard.
I move that we do it.
All right. Do we have a second?
I'll second.
All right. Dr. Christy Halbert seconds. Now for voice call vote, Donald Wynn? Yes. Patrick Wren?
Yes.
And Dr. Christy Halbert?
Yes.
All right, thank you, Commission. We'll move on to the next item was the June minutes. Although not everyone was present for the June minutes, I do trust that everyone had a chance to look at those, and if that comports with what they understand occurred at that meeting based on the video, and those minutes are acceptable to them, if we could have a motion in that regard, I would appreciate that. Do we have a motion to accept those minutes? Patrick Wren, motions to accept it. Do we have a second?
I'll second it.
Dr. Christy Halbert seconds. Is there any discussion, maybe edits or anything that they'd like to see in there? Okay. All right. For voice call vote, Donald Wynn, Patrick Wren, and Dr. Christy Halbert.
Yes.
All right. Thank you. We'll go ahead and come back to the budget since that's informational purposes, and we'll move to the 2019 meeting dates. If you had a chance to look at those, it'll be number 4 on the iPad. And we tried to mirror the dates that we had selected for this year. So that's it's the I believe the second Monday of those months quarterly at 2:00 in this room. And if that looks like that's something that would work for everyone, we also post on the website. That's something for you to mark and post your calendar. And if there's any changes to that, obviously we would let everyone know as necessity would permit us. If those dates work for everyone, if we had a motion to that regard.
Sure, I'll make the motion.
All right, Dr. Christy Halbert, she makes a motion to accept those meeting dates. Do we have a second? Patrick Wren, thank you, Mr. Wren. Now for voice call vote, Donald Wynn.
Yes.
Patrick Wren?
Yes.
Dr. Christy Halbert?
Yes.
All right, thank you so much. Those are the dates then. Now for the legal report.
Members of the board, today we have two cases for consideration on our legal report. I wanted to, before I go forward, I wanted to give a brief overview of our complaint process, just because we have two new members of our board. The way that we split up responsibilities here is I work the disciplinary actions and Liz does really everything else. But how our discipline works here is under a new centralized program. If anyone in the community or our inspectors, board members has a complaint that they believe someone in the industry is acting outside the laws and rules of this board, they can contact our centralized complaint system. That complaint is recorded. Usually it's sent for a response from the person the allegation is against, so they can make a statement. It's not always. If I believe or we believe there's fraud involved, sometimes we will go ahead and investigate first. At that point, every complaint, regardless of how it works out at centralized, comes to my desk for review to make sure that any legalities might have been overlooked just because everyone agreed that there. A lot of times people work it out, but that doesn't mean that there weren't legal violations outside of the dispute. I review those cases and I draft up a summary for you all to review. We keep it anonymous as possible. I try to also eliminate designations of which side of the state it might have occurred in, with the idea that this board will review this complaint anonymously and determine in your best judgment whether, one, if a violation did occur, and two, if it did, is this something we want to take action on, and third and finally, what is the most appropriate action to take. What we recommend here is actually a settlement offer functionally. It is not, may not actually be what the ultimate discipline is. So here I will offer and say, this is what I believe this case is. This is whether I think this is a good penalty for compliance. We're always about trying to get everyone to come into compliance. That's really the most important part. This is what I think is the most appropriate action. At that point, I take what the board wishes and I take it to the individual with the allegation against them. So they have an opportunity at that point to accept the terms, or if they would not, they don't accept those terms, we move on to a formal hearing, which is really just a trial, a little more informal, but functionally in a trial. With this board, an ALJ will come, one of our judges from our panel with the Secretary of State will come down and will put on the evidence to you, and the board gets to make that decision, what they think happened, and assess discipline. We don't have many of them, but if we had one recently, so they do come up. If that ever does come up, obviously we'll do our best to explain that process in a little more detail. But that's really the wide overview of what we do. We take in complaints, review them, process them, and do the best we can to make sure our consumers are protected, but also that our licensees and participants know what they're responsible for and they're given opportunities to come into compliance. I say this, if you, in your experience and in your involvement in the community, ever feel that a complaint is warranted, please feel free, likewise, to reach out to our complaint division. You also can reach out to me and to Glenn, but ultimately we'll probably defer you to there eventually. But if you ever want to discuss any matters, you can always try to let us know. We'll do our best to direct you. If you ever feel that you know who someone is or what something is, I ask that you recuse yourself on the record. There's no harm in that at all. If anything, it's better for everybody. So if you happen to just get an inkling, feel free. That is always in your judgment, though. So we defer to you. And if you think you can be objective, even if maybe you heard something on the news or in the industry, if you think that you can be objective, that is your call to make. So with that, this is a pretty short legal report. I'll hop into it. Our first case today is dealing with a registered boxer, 2018-04-041. That number is just how we track the case. This is a 41-year-old combatant, currently holds a 136-1 record in the state. This individual was recently suspended in Kentucky due to medical concern and ultimately underwent an evaluation with a neurologist that serves as part of the Kentucky Commission's medical advisory panel. The neurologist concluded that the respondent should not return to boxing just due to the number and frequency of punches they had taken, the age, fight record, and the neurologist's observations from the previous fight. So the neurologist actually attended one of the last bouts this individual participated in. Ultimately, there was a settlement. Obviously, there was some dispute about that. Kentucky opted to lift the suspension in exchange for respondent surrendering his registration, so it didn't look like it was taken away. The hope honestly, the intent was so that other jurisdictions like us wouldn't necessarily read into that, and that we would be able to make our own individual determinations. Some states you'll see, and we can do it too, but some states will see that someone had it revoked and just automatically go for revocation. I think this was an attempt to give this combatant a chance to have a factual determination by each board before that happens. So that was ultimately what they settled on. The suspension was July 7, 2017, and they changed that suspension to a surrender on November 20th. And on February 2nd, the respondent applied in Tennessee. So after he had been revoked in Kentucky, he applied here. The bigger problem, I think, especially from a legal perspective, is on the application expressly asks, have you been suspended by any state or other sanctioning authority? And he answered no. I think there's, obviously I'll leave it to you, there may be some confusion since the whole point of the settlement was to get out of having to answer those kinds of questions. But our application doesn't necessarily restrict it to what your status is currently. It's if you've ever been suspended. And so he has been. And so the truthful answer in this case would have been yes. And so typically in these cases, when we have a yes on an application, we would look into what that suspension was about, and it may result in them not becoming licensed here depending. And so a lot of the times when we have that question answered and a license was issued, we seek revocation of the license in order to set the respondent back to the base and let them reapply again with a truthful application. That's one avenue of options. But in addition to that being something we've done before, I think the concerns from Kentucky are warranted for consideration here. And so combining the fact that Kentucky doesn't believe this individual is capable medically of fighting and that we didn't get a chance to review that information, I recommend this board authorize the revocation of this individual's boxing registration.
Something that you wanted to discuss, or if you had any comments, concerns that you want to direct to the disciplinary council, this would be the time for that as well. We could take each case by case since it's a small legal report.
Satisfied with what I had read and what you just outlined to be able to make a decision.
Or questions? Okay. All right. If we can have since we have a small report, we can just take a motion in that regard. If someone wants to motion to accept disciplinary council's recommendation. All right. Patrick Wren moves to accept council's recommendation. Do we have a second? Dr. Christy Halbert seconds. For a voice roll call vote, Donald Wynn?
Yes.
Patrick Wren? And Dr. Christy Halbert?
Yes.
Thank you, Commission. They were so accepted. Now to the second part.
Sure, this is a little different. When you see represent, that just means I'm back again on a case. Sometimes I'll bring them back. Things change. We learn new things. This is a case we actually put on the shelf temporarily while we waited for Kentucky to figure out what they were going to do. We were notified that a combatant that was licensed here and in a number of jurisdictions, he's a professional MMA combatant, was charged with second-degree rape related to the sexual abuse of a 14-year-old minor. In our state, we currently under our laws, we don't have a statute or a rule that really gets us access to discipline a licensee for a criminal behavior that isn't directly tied to a bout or to the industry. But what we do have is the ability to discipline a licensee if they are disciplined in other jurisdictions. So since this was an individual who had licensure in other states, we wanted to wait to see what other states did and to see if it ended up warranting any action on Tennessee's license. Ultimately, the home state where this combatant resides, his license had expired, and so the jurisdiction was removed from that state anyway, and the charges have ultimately been dropped for a lack of evidence by the district attorney in that jurisdiction. So for those reasons, I'm bringing the case back with the recommendation we close it.
Oh, if you could just speak in the mic there. Sorry, it's we got capture on the. Yes, sir. Patrick Wren.
I would move that we accept the recommendation.
Thank you, sir. Do we have a second?
Second.
Dr. Christy Halbert seconds that motion. Now for a roll call vote. Donald Wynn?
Yes.
Mr. Wren?
Yes.
And Dr. Halbert?
Yes.
Thank you, Commission.
That concludes the legal report today. So, sure, I really appreciate your help. Thank you very much, members.
Thank you.
Great. If we can, we're going to skip probably the legislative updates for now. We'll return back to that so we can get to some of the potentially actionable stuff. We don't necessarily have to move on the next couple items, but if there's a possibility for that, we want to honor Mr. Wynn's time and make sure we capitalize on that. So if we can, let's move to the amateur deregulation rules package. Now for these items, you'll have the printouts in front of you. Those will become important. None of these items are on the iPad, so you'll be referring to those items. For the deregulation or the amateur deregulation rules package, we're going to be looking at the form that says amateur rules, and that would be chapter 0145-01. And then we're primarily looking at the second page to that. Of course, you've got you have this rules package's entirety, but we're looking at this was already voted on by the prior members to be approved, except for this provision that was added to amateur event. If you look at the very top, we're defining what the event means. We had not previously done that in the AG's office. They asked us to do that, so that way there's some consistency with the statute. They wanted to see that same language in statute with the rule as well. So it just kind of reads the same. Of course, I'll be leaning on our staff attorney as we go through this process. She'll be able to really shed some more light on it. But the primary reason we were doing this was let me just give you the quick history. There was when the rules were first written, they were kind of written as a catch-all. We would only recognize those amateur sanctioning bodies that were as strict or stricter than professional sanctioning bodies. So what that did was that was a springboard to statute that required medical ambulances at those events. It was also a springboard that required a $50,000 in medical insurance as well. Basically, it treated all amateur sanctioning bodies, put them on the same level as pros. Now, just on the outset, unless you're in the industry, you wouldn't necessarily see a problem with that, except for you understand that with these feeder organizations or after school programs, you don't necessarily need an ambulance there. You don't need $50,000 medical insurance to cover a life flight when kids are putting, they got the big weighted boxing gloves and the helmets on and things like that. So we knew that we needed to get with the industry standard and get current. So this rules package came out of that. We carved out, or the commission carved out those organizations that are those after school programs, those organizations that are for point kickboxing only. I mean, it's not full contact. Obviously, we don't need those professional requirements there, and so that's what this rule package did. It went all through up the chain and back to us, and AGs came back and said, they don't have any problem with the package, except for they want to make sure that it reads consistently. The only thing that was picked out was they wanted event described or declared, and so at the very top of page 2, where you see event was striked out in red. That's what the prior rule was. And then in blue is what we're replacing that with. That's the only issue that needs some clarification and action by this board. The rest of it's already been accepted by a prior board. So that's the issue. We don't necessarily have to vote on that today. However, if upon reading that, if you don't have any problem with that, since it was is supposed to read inconsistency with statute, then the verbiage there, then we can move on that so we don't stall these any further. However, we don't have to today. So it's really up to the will of the commission.
Can I ask for clarification
Yeah,
on
of
part
course.
of this? So looking on that second page, it's in the blue marked 11.
Yes.
At the very end, it says, and is not promoted or organized by a promoter. Is that promoter defined as in the statute? Promoter means any person who produces, stage, or sponsors any professional contest of unarmed combat.
Yes, we're referring to the same definition, and that is part of the reason why the Attorney General wanted us to make sure amateur matched up with the statutory definition as well. So what we're looking at here, Glenn mentioned previously, we have added in the second portion of the definition of amateur to match up with that's listed in our statute. Previously, that was left off. We want consistency. The AG wants to promote consistency throughout our rules and our statute. So essentially, when we have a change like this that's more than just grammatical, the AG looks at it as a substantive change, and any kind of substantive change needs to be revoted on by the board or commission to move forward. So if you have any other questions, this would be a good time for those.
One more.
Yeah.
So the commission would still require the event permit, correct?
Those that are carved out and exempt would not require a permit. Like for example, and if you were reading the rules, there are those that, and I have to borrow from legal, but I'm looking for the perfect example, like the point kickboxing. In that regard, they're exempt from regulations from what would be considered an amateur, or they're specifically named, and so as a result, they wouldn't be regulated.
So do those organizations then apply for an exemption, or or is the Tennessee Athletic Commission?
Typically, if there's any questions, they reach out to us already. It's a small group. But if they were to engage in what would in essence be unlicensed activity, then they would, be subject to any of those consequences, repercussions that would come to that. But typically we send out notifies, we post on our website as well. Changes like this especially. These are, pretty substantial to those industries, but a lot of them are already watching these packages, as they're coming through. So this is something that they've been waiting on and been looking forward to. So, I suspect there'll be a learning curve, like as with all things, and we're ready to make those adjustments as necessary.
And it's part of, we touched on this a little bit earlier during the board member orientation, but as part of the rulemaking process, we always welcome comment from the societies and organizations or individual consumers on the rule. Like Glenn said, we will send an electronic notify once these rules are filed with the Secretary of State, and they will be sent to everyone that is signed up on our notify system, which is most of our licensees. And at that point, if they would like to make comments, we will save all of the comments and present them to the legislature when we go for our very final review with the Government Operations Committee. So if anyone has any comments in favor or opposing the rules, they have plenty of time to send them in. I believe Glenn and I have saved a few emails now with some amateur organizations that have sent in comments supporting these rule changes. So we will submit those to the legislature as well.
Any amateur events would still be subject to a event permit, just not the ambulance requirement and the medical insurance. The only ones that would not be subject to an amateur event permit would be those specifically named, because they're not considered a true amateur event, not requiring.
Thank you.
Donald, for your benefit, and while the other members are deliberating, let me read how event is described here. Under the amateur definitions, event is defined as means an amateur event in which amateurs compete in an unarmed combat sport competition in accordance with Title 68, Chapter 115. Event does not include sparring, wherein amateurs engage in unarmed combat for practice and non-competition, and is not promoted or organized by a promoter. So there's the exception to that event. So basically, just as it comports to 68, Chapter 115, we're just driving the consistency there. Otherwise, the rest of the package remains untouched.
Got it. And Glenn, you guys kind of cut out a little bit. Are we ready to vote on this, or are we still deliberating?
We're deliberating. Do we have any further questions about this portion? Just this portion, not the rest of the package. That was already handled and then dispatched with. But just on this portion,
Good.
Okay.
I just want just to clarify once more. So, an amateur boxing event, the organizer of that event would apply for an amateur event permit, and then they may or may not be required to provide the ambulance and I can't remember the other.
If they're recognized as an amateur sanctioning body, they will not be subject to the ambulance requirement and the medical insurance, that $50,000 medical insurance. That's correct.
Part of the testimony that we heard earlier this year from some amateur organizations that were urging amendments to our current rules were the burden and expenses of the ambulances, that there weren't a need for them, that they had other medical professionals on site in the chance that something did happen. But with the no sparring, the chances were very low that someone was getting injured to the level of the ambulance needing to be on site.
And they're still subject to their sanctioning bodies. So deregulation is kind of it's confusing because they're still regulated. They're just not regulated by us, by the Tennessee Athletic Commission. They're regulated by their sanctioning bodies, which have to be recognized by the Tennessee Athletic Commission. You know, we're just not holding them to that of the pros. Okay. If we have a motion in that regard to accept the definition of event, Dr. Christy Halbert has made a motion to accept that. Do we have a second?
I will second.
Mr. Wren seconds. Now for voice call vote, Donald Wynn.
Yes.
Patrick Wren.
Yes.
Dr. Christy Halbert.
Yes.
All right, thank you very much. I think we can go ahead and send that back to AGs and get those and hopefully get an effective date here soon. That brings us to Rule 0145-03-02 amendment, and that has to do with vinyl mats. So if you want to pull that rule or that package in front of you with the vinyl mats, this one we don't have. This is a new rules package, so we don't have to vote on this one today unless we're just absolutely comfortable with it. But we at least want to introduce it in the conversation so we can get that one started. I'll give you the background first. I'm going to orientate you to the rule itself. On the second page, part 2 of that, I'm going to go ahead and read that. In the blue, before it said vinyl or other plastic rubberized covering shall not be permitted. That's what we're excluding. All right. And what we're adding in place of that is materials made up of 100% vinyl or 100% plastic rubberized covering shall not be permitted. Blended materials may be accepted if approved by the commission, the executive director, or the executive director's designee prior to use at a contest. Blended materials include those of which the surface contains a combination of vinyl or similar synthetic materials. The executive director or the executive director designee shall make a determination of approval based upon whether or not the material creates an unreasonable risk of harm to any combatant that is not present with the use of standard canvas or duct type material. Such danger shall include, but is not limited to, slipping, falling, or tears that could create lacerations to the body. The executive director may publish a list of material blends that have previously been determined as acceptable by the commission. What this came out of is the industry is always changing. It's fluid. It's moving. Technology is introduced, and the vinyl mats. Obviously, we didn't. The old vinyl mats, we didn't want those because they are slippery or sticky when wet. When they break, lacerations to the body. So those were problematic. So that's why that rule was there. But now there's hybrids coming in. What do we do with the hybrids, right? Because it was what we're taking out is vinyl or other plastic rubberized covering shall not be permitted. Well, but right above that said the ring refining area shall have a canvas covering or similar material. Well, what we're doing is we're describing that similar material. There's some hybrids that could potentially be acceptable. So we're trying to include that and allow that for these events. So we don't want to be more restrictive than necessary, than the industry would allow. Because at the end of the day, it's about public protection. And so if that level can be met comfortably within the rules that are slated here, then we would move on that.
And we wrote these rules to give the commission some leeway to determine case-by-case basis whether or not one would be acceptable and would cause harm to the public or not. Previously, the rule was a little bit more vague and didn't really allow us a lot of room to approve these hybrid materials, which some of them seem to be perfectly fine and safe enough for these contests. So this is just our first draft, our first stab at amending this rule to reflect what past commission members have suggested. So there's certainly room to edit this or add or take away anything that you new members or Mr. Wynn, if you want to comment, would like to switch things up. This would be a good time to discuss it if you'd like. we can come back for a vote on this one in December at the December meeting if you'd like to make changes today. So don't feel as if you don't have the platform to make changes. That's what the discussion is for, really. So we would love your input or your thoughts or opinions on this amendment. But Glenn and I both think that this would be a positive move for the commission.
So definitely, but I do have a question. What would then be the process for the executive director or their to make a determination of approval? Would that be before the organizer or promoter orders the new canvas, or is it done on site?
They should contact the commission before they make an order, and they would need to get it approved before they used it at any event.
That designee is the inspector. That's typically what we have in mind. It's a last catch effort. You know, if they get there and they realize this isn't what was approved, you know, or they have some questions about that, and then based on maybe the body of knowledge that has since been collected through these kind of conversations, they can make that determination. That way, they're not locked and they have to cancel that event. But at the same time, too, that gives them some latitude.
Yeah, it's been my experience in both boxing and kickboxing and MMA events that when it comes down to the event itself, the inspector on site carries a lot of weight. And the requirements, I'd like to have a little more time to look this over before I make a decision, because I would want that inspector on site to really know what he was looking at and not have any confusion that's going to cause some guy to slip and tear his knee out.
We welcome that. I'm actually sending these to you. These are, you take those home with you. Right. Those, but then I'm also going to send you these rules package, and then we'll put this on the agenda for the December meeting.
Beautiful. And
then hopefully by then we can add some more conversation, and we can take this first draft and move this along to a place that we're all comfortable with.
And if you don't feel comfortable discussing today, or if you think of, next week you think of a change you'd like to make or an edit, please feel free to send me an email with your suggested changes. I'd be happy to work on this draft up until the December meeting with new ideas or new changes to this section.
I'm glad to see us being proactive on something like this. And what's exciting about some of these new materials is they're potentially more hygienic for the combatants. So I like that.
Great. For the next item, TCA 68-115-403C discussion. This is primarily informational purposes. Let me just read the statute. You don't have it in front of you there, but it's a real quick blurb. A professional combatant shall be subject to additional blood testing for infectious diseases if more than 90 days have elapsed since the combatant's license was issued. So there's a couple words that we're looking there. We're looking at additional blood testing, and we're looking at shall be subject. So shall be subject means that within 90 days or outside of 90 days are subject to additional testing. Now that doesn't necessarily mean they have to be, but they're subject. It means we can require them to have blood work that's within at least 90 days before a fight. It's not mandatory. What we've been in practice, what we've been doing is just holding them to the 90 days. But we've had from listening to some of the promoters, obviously they have to afford those they have to take on those costs. Obviously, public safety is, we have to balance that, and that's primarily our concern. And so we looked at some of the industry around us, and out of the 8 states that touch us, let's see. The following states require blood work within 180 days. That's Georgia, Kentucky, Virginia, North Carolina, and Missouri. With Missouri requiring 90 days and Alabama requiring 1 year. So they have to, before they get their license, they have to have blood work within 30 days. But then if they fight again, 91, 92 days, they got to get that blood work again. A lot of the states around us are allowing at least 6 months Whereas right now, just as a matter of practice, until we got some input from the commission, we were just, as a matter of practice, just requiring that they get us more blood work within that 90 days. This commission before has already had that discussion, and they were open to opening it up to 180. But since we have a new commission, wanted to make sure that we had that discussion as well. And so, but yeah, we're free to do that. We can follow the other commissions that border our states, and just we're still require shall be subject as shall be subject on a case by case basis. We see a situation, there's somebody tells us something that requires us, that concerns us, then we can require that, and they would have to go and get that blood work, shall be subject, and then at our directive, go get that blood work. So we're not hamstringing ourselves by necessarily expanding out 180 days, but we're not requiring as a matter of policy any longer either for everyone. So if that's the will of the commission, then we can take that course of action. But we're free to do that within the statute. I'd love to hear your comments on that, and what you would desire in that direction, in that vein.
So this is once they've gotten the license, correct?
Yes, ma'am. Additional blood testing. They've already got the license. They got their license, and their blood work was within 30 days. And so now they want to have a fight 4 months out. And then as a matter of practice, by our own internal policy, we've been requiring them to get additional blood testing. But if the commission was so to direct us, and the statute would allow, the statute does allow up to 180 days, we could follow the other commissions and say, as a matter of practice, we won't any longer require the 90 days, but we'll extend it out to 180. But of course, leaving ourselves the option to exercise our discretion if information was to encourage that.
Hey, Glenn, this is Donald here. I'm going to have to drop off. Are there any more items we need to vote on?
No, sir, that was great. Thank you so much, Don. I appreciate your patience and for locking in. All right, you take care.
All right, thank you.
All right. The rest of our meeting will be for informational purposes. Obviously, we won't be making any more votes, but nonetheless, these are good discussions to have. So, did you have any comments or any concerns or questions in that regard? And we can provide some of the historical on that as the best we can.
Voters will be in favor of this, certainly.
I would think the promoters would be in favor of it. I would think the fighter would be in favor of it, because I've been in a number of situations where 5 minutes before the event was on, they were having to hunt down a doctor to do a blood test on a potential, fighter. And I could see where that would give some room in the business for these people to, once we were sure they were clean on the front end, to go out and ply their trade, do what they had to do, but still give us the opportunity to require it if we thought there was a necessity for it in a particular case.
That seems reasonable. That seems to be the general consensus that we were receiving from the other commission as well. So, going forward, I just wanted to get your input before we exercise in essence, it's not a new policy, but in recent events, it would be a new policy for us. So, administratively, as we proceed, we wanted some direction from the industry experts. So, thank you very much.
As Glenn might have referred to earlier, this is not necessarily set in stone. Our statute gives us guidance here and gives us some lenience as to how many days. So if further down the road the commission becomes aware of more situations where you feel that this would be a safety risk to the public, to the other fighters, we can certainly revisit this issue.
Okay, since we've covered a lot of ground in a short period of time, and so I thank you for that. What we're going to do is since Donald Wynn is no longer with us, and we got past all the actionable events, and we're grateful for that, for locking in with us and for your attention in that regard. But we're going to pick up all the pieces we missed on our agenda. So if we can go back to the budget and have that discussion, that was number 3 on your iPads. And then after that, we'll follow up with legislative updates and then new business, and then we'll be done. All right. I'm going to spend a little time here talking about this for obvious reasons, the net deficit, but also as kind of a tutorial, since this is going to be the first time you're seeing our process or our budget. So let me see if I can explain that. And if you have any questions on the way, please stop me and I'll be glad to clarify the best I can, okay? All right, so we've got the first paragraph up there. You got athletic commission revenues and you got expenses, right? So we take it, what we take in as opposed to our expenses. It's a regular balance sheet resulting in a net surplus or deficit. And then I'm going to stop along the way explaining what those are. The revenues, licensing revenue, that's pretty simple. That's just licensing. Anytime someone, sends an application, seconds, to combatants, whatever, that's the licensing. Case revenue is anytime we render a judgment against somebody in a disciplinary action, that's the payment that they put. Anytime it's kind of like a speeding ticket. That's a fine that they're paying. Case revenue. That's what that is. So those are considered revenues. State reg fee. It's basically a workaround. The fiscal, they charge us $5 per license to print those licenses. We don't do those in-house. So it's not, and this is accounting speak. I don't have an accounting degree, but they don't consider it an expense in the truest sense. It's more of a workaround, so they put it in the revenue column. I'm not sure why that would be, but if you see that there, why is there a negative in the revenue? Seems counterintuitive. That's why that's there. And so as you can see in July, $40 divided by 5, you're looking at about 8 licenses printed out. So that's what that is. That won't be very substantive. Now let's go down to TAC expenses. You've got Edison expenditures. Edison is our internal payment system. It's basically our ledger and our employment system as well. As employees of the state, you'll become more and more accustomed to what Edison is. Any travel that's issued comes out of Edison, but also what comes out of Edison and Edison and administrative cost backs. They have a lot of the same line items. Like you'll have rent, you'll have staffing, salaries in that regard. You can get a better view of that if you go to page 3 of what those Edison expenses and administrative costs look back. If you scroll over 2 pages on the last page, those are Edison expenses right there. You've got, as you can see, travel, repairs, vendors, buildings, rent, all that kind of stuff. And that's where that shows up. So let's go back to the first page again. Administrative cost backs. Administrative costbacks include the Athletic Commission share of the liquidation of all administrative costbacks from the programs. The share is determined by licensing count of complaints, or number of complaints, and budget plan, which accounts for 0.44% for TAC versus 16% for cosmetology and barber. Now, the reason why I tell you that is what it comes down to is there's certain administrative costbacks that aren't necessarily unique to the program in question, but are across the board for all regulatory boards. So how do they figure those up? Well, if we're all in the same building, do you have an equal share to this small program that you would have to this program over here that's large and a behemoth, So I took one of our larger programs that we look at, like cosmetology and barber, who has 60,000 licensees, so you can get a proportion view of why our administrative cost backs are only 0.44% as opposed to cosmetology and barber's 16%. And how that looks in real dollars is for this month, for June, it resulted in an expense to the TAC of $350. Well, cosmetology and barber, their expense for the month of June was $48,000 out of a $300,000 total budget, because we share this building with architects, engineers, and the land surveyors and the like. So that's where that comes from. So when you see administrative cost backs, that's what you're looking at. But they have a lot of the same accounts as Edison. So when you see the Edison breakdown on the 3rd page, when I send that to you, that's the certain itemized line items for our general expenses. I think we have a pretty good view of that. As you can see, and let's go down a little bit further. Legal cost backs, the disciplinary action report. The attorneys, we're subject to the billable hour. Anytime they work on these cases, they're billing us by the hour. Of course, Sarah, she works for other boards as well, and she only apportions to us which went for the time that she works on TAC. So that's what you have there, legal cost backs. And if you see something like, March had a $2,000. That's probably we had probably a few more cases then, so that's sporadic. It really depends on the cases that come through. If they're working on a formal hearing, well, you can imagine it can explode. Last year when we were working on the one formal hearing, a little bit more cost there. Investigation and field enforcement closely related. We don't see a lot of investigations. we don't typically need industry experts, vendors. Like if you were in the Tennessee Real Estate Appraiser Commission, they have experts they have to review. So that you have to hire a vendor to go check and look at an appraiser, a licensed appraiser, and pay them their rate. We don't have to do that. We have inspectors and that's why inspections is typically the lion's share of our expense. When you take 4 to 8 staff and you have them overnight at a hotel, and they're sitting there all day and you're paying them their rate, that's what's eating into our budget. We did find a way to mitigate some of that. If you look on the budget, you'll see a huge drop off at about January. You see the rate is like 5,000, 1,300 wasn't too bad, 5,000, 7,000, 5,006, and then it dropped to 2,000, 1,500. One way we mitigated that expense was hiring part-time inspectors. We pay them $100, and they're local, so they're not typically staying overnight. They're not getting that per diem rate. And so we're able to find some savings there. If you're concerned about, and then of course, Customer Service Center, before I get to the conclusion, the Customer Service Center is basically our call center. And they have, they take about the number of complaints and calls that come in, and then portion us what our share would be of that. It's pretty nominal. It's not substantial. Rarely do we see, and usually it's pretty proportional to the legal cost back. So obviously, if you're getting a lot of calls, complaints, or whatever, that's going to show up in the legal. So and then at each month of the fiscal year, we have a net surplus, net deficit. As you can see, we've been running in the red primarily. So the next page, page 2, will be a particular concern. We're running right now in the deficit of $46,000 for the year. But last year, this is our snapshot for fiscal years. If you look at the very bottom to the right, our reserve balance of last year was $32,000. So we'll offset that 46 a little bit there. Okay, so that's good news. However, we still got $14,000, that was in the red. Now, where that becomes important is we're by statute required to be self-sufficient. They look at a 2-year cycle. So that means next year, either we'll have to bring in more revenue. We feel like we've mitigated a lot of the expense with the field enforcement, so we've kind of plugged that hole a little bit, And so if another big show was to come through there, I think the revenue from that would really make the difference and offset that. And so they're going to look at those 2-year cycles. So no reason to be alarmed as of yet, but at the same time, too, something we want to continue watching and keeping our eye on. That's just for your information. If you had any questions, I'll be glad to answer those. But I think that just kind of give you an overall view. Sure. All right. And then there's nothing for us to vote on there. Typically in the director's report, I'll bring other action as well. Maybe something that's coming on the horizon administratively, something that we need to discuss. We don't really have anything like that today. We already covered the meeting date, so we're good there. So that really brings us to the legislative updates.
We covered a few of these updates in the board member orientation. One of those was the Fresh Start Act that was recently passed in this year's legislative session, and that, as a brief overview, changes the way that we approve or deny a applicant if they have a felony on their record, and it also changes the way that we assess discipline. I did want to clarify that earlier Ms. Page did bring a case before you that sounded like it did have a person who was on the sex offender registry, and I mentioned in our board member orientation that there are exceptions to the Fresh Start Act, and that is one of them. I believe that case was brought to us prior to that act being effective, so that's why Ms. Page didn't bring those considerations before you today. So just to clarify that. Let's see. I think that was the only one that affected our board from the legislature. I did want to update you on 2 other rules that we have moving through the rulemaking process. The medical insurance coverage reduction rule. That is one we worked on this past year to reduce the required coverage from $50,000 to $20,000. We had a lot of support from the industry on that one, and we are taking it before the Government Operations Committee on September 26th. That's the final step of the rulemaking process. So that one is at its very end. We've not received any opposition yet. So if the committee votes to approve it, it will be effective on October 9th. So that's good news that we've got our rule moving quickly through the process there. I believe that one was first approved by the program in December. And then another update on rulemaking would be our rules that cover weigh-in hours and weight classifications. I've got a copy for our new members here today that I'll pass out at the end of the meeting, but I didn't want to cause confusion with the rules that we were discussing. But I did want to update you that we have been in discussions with the Attorney General and have a few cosmetic updates to send back to them, and then it will be moving through the process as well. So we should have an effective date for you guys at the next meeting on that one. So it looks like we've got a total of 4 packages that we're working on right now. One is almost to completion. Another one is getting towards completion, and then the one that you voted to add the definition of amateur on today is getting back on track as well. Were there any questions about the rulemaking process or any of the rules we covered today? Okay, thank you.
All right. Well, that brings us to new business. So, would you like to, first of all, before we even get new business, this is backwards, but we had to do that today just because we had Donald Way on the phone. But I'd like to introduce both of our new members. If we may, Dr. Christy Halbert comes to us with a wealth of boxing background. Been in the industry for how many years? Long time, yeah. And the background was pretty impressive as both of our members, but USA boxing team and has a background there as well. And so we're just glad that as our boxing industry expert that you're going to be on the panel. If there's anything you would like to say, you're welcome to it, but I don't necessarily want to put you on the spot, but we're just glad to have you here with us.
Very happy to be here as well. Thank you for the opportunity to serve.
Of course, Mr. Wren, he is our mixed martial artist expert as well, coming from West Tennessee. Wealth of information and background as well. And if you don't mind, if you want to jump in and just kind of tell us a little bit about yourself, that'd be great.
Jump in and do what?
Just tell us a little bit about yourself. I saw your resume, but I don't know if I'm afraid I'm going to butcher it, is what I'm afraid of.
I have a degree in English literature. I was going to be a poet, and I ended up being a 10th degree black belt with 52 years as a black belt in this state. I was involved in the very beginning of kickboxing in this country. The first middleweight world champion was my guy, and it went from there. I was fortunate enough to have trained a fellow named Aaron Pryor, who was the 2-time junior welterweight world boxing champion. I trained Kennedy McKinney, who was an Olympic gold medalist in Seoul, and then came back and was 3-time bantamweight world boxing champion. So I've had a lot of experience that way, but my best experience has, I got a picture yesterday on my Facebook of a 5-year-old kid, and he took chalk and wrote TKI on the ground and put his Tennessee Karate Institute, put his hat on, and had his picture made to send to me. And that's what this is all about. That's where this starts, and we have a voice in where it ends. And hopefully where it ends is going to be somewhere that brings some glory to our state and our reputation as a competitive state in boxing, kickboxing, and such. And in that, it'll draw more revenue, draw more excitement to what I've spent my life doing, what Doctor spent her life doing, and fulfill a dream. So I'm really glad to be part of it finally.
I know Dr. Halbert also has a background with a lot, training the future athletes for this state as well. So we've got a good stock here of, and we really appreciate your participation in that regard. Thank you both. Unless there's anything else you'd like to add, that's what new business is for. So we can adjourn. But if there's something else you want to bring up,
I would like to bring
please.
something up. So in preparation for the meeting, I was looking at the current rules, and I have a recommendation or something we could discuss regarding Rule 01450219, and it's labeled. So my recommendation is this. Point number 1 under that heading says bouts between contestants of opposite sexes are prohibited. That, it seems like, is a general rule. It doesn't have anything to do with women boxers in particular. And the second part of the rule refers to women boxing in gloves weighing not less than 10 ounces, and then the Part B is requiring the pelvic and breast protectors. So my suggestion would be to strike that rule in its entirety and move bouts between contestants of opposite sexes are prohibited to a different part of the professional boxing rules. And then there's no evidence to suggest that breast protectors are recommended for women combatants, and USA Boxing, as well as most other boxing organizations, have done away with this rule or have made it an optional rule for women. If that's the case, and that's how we would want to move forward for the Tennessee Athletic Commission, then we could move the breast protector rule over to page 2 of the rules. So I'm looking at 01450206 subpoint 1, and then we would just add a C there, because A is about the low bro protector, so that would refer to women and men, and then we would add a C, and the C would read something along the line, and I would leave this to you for the wording. Female boxers may wear a breast protector.
We don't have the rules in front of us. If you would like to send those recommendations to us, and then we could put that on the agenda for the December meeting, and then I think we can work ourselves towards a first draft, because we'll be revisiting the other rule anyway. Or I'm trying to think which one we had.
I think those are great suggestions, though. I don't think that section's been touched in a while, so some changes would be welcome. If you would like to email me your thoughts that you just put on the record, I took some notes, but just to make sure I'm getting everything accurate, I could have a draft prepared for the commission to look at the December meeting. That way you'd have something written in front of you to see the red line of where the changes were made.
I have a real interest in it from the point of MMA competition, because that same situation is a consideration. So
great. We're going to be back visiting the vinyl mats rule. That's what I was searching for anyway. So when we get that one, those corrections or edits from you, we could add that one as well, and then we'll have that discussion in December. All right. Thank you. Was that it, or is there anything else that... Okay. Well, I'll make sure that's on the agenda then. If we can, well, we don't need to move to adjourn. We couldn't do that anyway at this point. So we are adjourned. Thank you so much.
thank you very much.